and OCASI's accessibility initiative. And we hope at the end of it all, you will be able to understand how human rights laws apply to protect the rights of people with disabilities, recognize and understand principles of accommodation, examine forms of accommodation, and provide examples of accommodation, awareness of the duties and responsibilities of people involved in the accommodation process. So with that, I invite Andrew Robb, who works with Disability Alliance. Andrew Robb is the managing lawyer of the Disability Law Clinic at Disability Alliance in British Columbia. The Disability Law Clinic is the first community legal clinic in BC that focuses on disability rights and laws. So welcome, Andrew.
Thank you. Can you hear me okay?
Yes.
Excellent. All right, well, thank you for having me today. Thank you for that introduction, Tekla. As Tekla said, my name's Andrew Robb. My pronouns are he and him. I am a lawyer with the Disability Law Clinic at Disability Alliance BC. And just so you know my background, I've been a lawyer for about 12 years. I've worked in Ontario, Alberta, and here in British Columbia. I've spent pretty much my whole career in the nonprofit access to justice sector. And I've been with Disability Alliance BC since March 2020, working for the Disability Law Clinic program. I want to thank Tekla for the Indigenous land acknowledgement she gave. I just wanted to add my own. As it says on the slide, this presentation is broadcast from the Office of Disability Alliance BC, which is on the traditional, ancestral, and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. And I am a grateful settler on those lands. I will give you, this slide shows the outline of my presentation. I'm going to start by talking just very briefly about Disability Alliance BC and the Disability Law Clinic. Then I will talk more about human rights laws in Canada, particularly some important concepts, including disability, discrimination, accommodation, and a legal term we often hear that's referred to as undue hardship. And I'll also talk about the duties and responsibilities of employers and employees in the accommodation process. Then I'll give you some examples of workplace accommodations, and I'm hoping we can have a brief discussion about that, depending on the time. I will talk about the legal process, including human rights complaints. And I will end by talking briefly about accessibility laws and accessibility standards, which I think are an important offshoot of or related concept to accommodation and disability, accommodation of people with disabilities in the workplace. And finally, I'll try to make sure we have some time for questions at the end. So as I said, I first wanted to talk about Disability Alliance BC. As it says on the slide, our mission is to support people with all disabilities to live with dignity, independence, and as equal and full participants in the community. I often refer to Disability Alliance BC as just DABC. And I can say DABC.
I'm so sorry for being a dork. I want to do well.
Thanks. So I think I heard someone who had unmuted themselves there for a moment. I was going to say DABC has been around for about 45 years. We operate several programs, mainly to advocate for people with disabilities and promote access to government disability benefits. And the Disability Law Clinic, where I work, is a program of DABC, and we provide free legal services to people with disabilities in BC in certain areas of law, including human rights, social assistance, and decision-making rights for adults with disabilities who are subject to guardianship and trusteeship. So that's all I'm going to say about Disability Alliance BC and the Disability Law Clinic. Next, I'm going to talk about human rights laws in Canada. And there are at least two different laws about human rights that apply in every province and territory. One of those laws is created by the federal government in Ottawa, and that law is called the Canadian Human Rights Act. And then in every province and territory, there is also a law created by the government of that province and territory. And these laws are based on similar principles, but they work in different ways and sort of in different areas of life. And this can be complicated because both the federal government in Ottawa and your provincial or territorial government have a role to play in preventing discrimination, but in these sort of different areas of life. And these are, it's the Constitution of Canada that says what areas of life are under the control of the federal government and what areas of law or of life and law are under the control of the provincial or territorial government. This is frankly confusing, and I'm not going to get into it in much detail, but I will say that if a person is considering taking legal action about a human rights issue, it is very important to get advice from a lawyer to make sure that about whether the issue that you are concerned about is under the control of the federal government or under the control of your provincial or territorial government. All right, so this next slide says human rights laws protect against discrimination based on disability in the workplace. And human rights laws define disability very broadly. It generally includes all of the following: mental, physical, and learning disabilities, visible and invisible disabilities, temporary and permanent disabilities. In other words, disabilities that might affect you sometimes, but not all of the time. It includes substance use disabilities, and it also includes perceived disabilities, even if those disabilities are not real. For example, if your employer or someone else believes that you have, let's say, a mental health disability, but you don't really have that, if they treat you negatively based on that perception of your mental health disability, that can still be discrimination, even if you don't actually have the disability that they think you do. And this presentation, of course, is focused on disability and discrimination in the workplace, but it's important to note that human rights laws also apply to, they also protect people from discrimination in other areas of life, such as housing, education, healthcare, other government services, as well as services from a private business or private businesses. For example, I'm going to be talking about how your employer is not allowed to discriminate against you. But for example, it's also the case that your landlord is not allowed to discriminate against you based on your disability, and neither can, let's say, a grocery store or a school or a hospital, for example.
That's the one, $20 million.
But that's not going to be the focus of my presentation today. My next slide it says, what is discrimination? And what it means is any action or decision that causes a negative impact on a person based on their disability. Some examples might include firing someone or reducing their salary or benefits, or if there's an assault or harassment in the workplace, that can count as a form of disability, or failing to offer reasonable accommodation. And I'll talk in just a minute about what reasonable accommodation means. I want to note for now that, again, I'm focusing today on discrimination based on disability, but this same definition of discrimination would also apply to actions or decisions related to other, what we call protected grounds. In other words, grounds that are protected by human rights laws, such as race, religion, sex, sexual orientation, and gender expression. And this list of prohibited grounds, it varies depending on which province you are in and whether your employer is regulated by the federal government or by your provincial or territorial government. But all human rights laws in Canada protect people from discrimination based on these grounds or something very similar to that, to these grounds that are listed here. I'm on to my next slide now. It says, in order to avoid discrimination, every employer has a duty to provide reasonable accommodation up to the point of undue hardship. And I'll talk a little bit more about these terms in the next couple of slides. But what accommodation basically means is sometimes treating people fairly and treating them equally means treating them differently from others. And that's why the law includes what we call a duty to accommodate. And this duty is a responsibility by employers, in our context, to take reasonable steps to provide accommodations that an employee needs in order to do their job. And this is how avoiding discrimination is connected to the employer's duty to accommodate. One of the things I want to emphasize here is employers have a duty to provide reasonable accommodation, and the word reasonable is important. The legal obligation is not a duty to provide perfect accommodation, and it does not require employers to do exactly what the employer has requested that they do. They just need to, the employer that is, just needs to act reasonably. And an employee cannot reject a reasonable offer of accommodation unless they have a very good reason. This means sometimes employees must be willing to compromise, even if the accommodation proposed by their employer is not exactly what they want. I'm moving on to the next slide, which is about undue hardship. And as I said before, undue hardship is sort of the limit on the employer's duty to accommodate. If an accommodation would create undue hardship for the employer is not required to provide it. So this slide is about what are examples of undue hardship, and how do I know if an accommodation request is reasonable? And what it says is the law weighs several factors together to decide what counts as undue hardship. Some of these factors are the financial cost of the accommodation that's requested, any health and safety risks that might be associated or might result from the accommodation. Another factor is the size of the employer and the resources available to them, and the impact on the rights and interests of other workers. I want to emphasize that undue hardship is rare. Most accommodations require some amount of financial cost for your employer. But that does not mean that they hit this limit, this concept of undue hardship. That's just because there's a cost, that doesn't mean it's undue hardship. The cost must be very high for the employer to use this as an excuse. And how high that is going to depend on how big the employer is. So for example, if your employer is very small, they only have 3 or 4 employees, they are not going to have to do as much to accommodate you necessarily as a much bigger employee. Let's say if you work for the government, or if you work for a big company that employs hundreds of employees, they are expected to spend more and to do more if necessary in order to make sure that their employees receive reasonable accommodation. Some accommodations might inconvenience other workers. They might annoy or make other workers angry at the person who is receiving accommodation, because there's sometimes a perception that a person who gets accommodation is being singled out for particular treatment. But inconvenience alone does not count as undue hardship. Just because other employees might not be happy with the accommodation one employee received, that on its own would not be undue hardship. The specific circumstances of each case matters. As I said before, the size of the employer makes a difference, and also the degree to which an accommodation might affect safety and health in the workplace, or how much it might affect how other employees feel about the situation. These are factors, but they are not always going to be on their own. They're not going to always count as undue hardship. So next, I'm moving into a slide about what are the employer's responsibilities in the accommodation process. As it says here, if an employee says they have a disability and asks for accommodation, the employer should take the following steps. They should consider what accommodations they can reasonably offer. The employer should request only the information they need from the employee in order to determine how to accommodate that employee. If there really is no accommodation possible for that employee's position, then the employer might have to consider whether another position could be made available. And this is one of those things that a very small employer might not necessarily have to do, but a large employer that employs hundreds of people might have to consider whether another position could be made available, even if a person is no longer able to do their current job due to their disability. The employer should also maintain confidentiality about the employee's request and about the employee's disability. And lastly, here it says the employer should respond to the request in a timely manner. In other words, they can't make the employee wait for a very long time. They have to act pretty promptly upon getting a request for accommodation. I often get questions about how much information a person must provide to their employer in order to support their request for accommodation. And like a lot of, issues within human rights law, this depends on the individual circumstances of the case. But in general, the employer is allowed, that is your boss, is allowed to ask you for a note or a report from a doctor or another healthcare provider that supports your request for accommodation and explains how it is connected to a disability. However, if there is any cost for getting a note or a report from your doctor or from someone else, the employer must pay for that cost. This next slide is about the employer's duty to inquire. And this is another legal concept that, that we have heard about in relation to human rights laws. And it means that if the employer notices that an employee is struggling at work, and there is reason to believe that their struggles could be connected to a disability, the employer should talk to the employee about whether they need accommodation. In other words, they should inquire and ask questions about why these performance problems are happening. If an employee is fired for a reason related to their disability, that might be discrimination, even if the employer did not know about the disability. Because sometimes the employer should have known that they should have asked about the disability before they fired the person. This means that usually the employer has an obligation to ask questions about whether a disability might be causing performance problems before they decide to fire an employee because of those performance problems. I see a question in the Q&A section about what if multiple notes have been provided and the employer responds by saying they need to take their time to consider. And I know this is a question, or this is similar to questions that I hear about pretty often, because I told you a minute ago that employers must respond promptly. I know that doesn't always happen in real life. Employers are allowed to take some time to consider a request, but if an employee has provided all the medical information that they can and has tried to answer all of the employer's questions, if the employee has done that and the employer has not responded within a couple of weeks, my advice to the employee would be, you should start following up with the employer on a regular basis, by email or by phone, probably once a week, until you get some kind of response from the employer. And you should be polite and professional and respectful about that, but there's nothing unreasonable about following up if the employer is not responding promptly after the employee has provided all of the necessary medical or other information. I'm moving on to the next slide now, which is about the responsibilities of the employee, in other words, the worker, in the accommodation process. The employee should tell the employer they need accommodation. Even though the employer sometimes has a duty to inquire, it is usually going to be easier for the employee if they can bring up the issue of accommodation in the first place, rather than waiting for something bad to happen and then going to the employer and saying, well, that happened because of my disability. The employee should also explain how their disability affects them. so that the employer understands what accommodation might be reasonable. And it's, as it says here, the employee should consider an employer's accommodation offers in good faith. This means that if the boss or the employer, if they provide some form of accommodation, or if they propose some suggestion for how the employee can be accommodated, the employee, the worker, usually has to give that a chance and only reject that proposal or that proposed accommodation if there is a very good reason for it. I would also add that whenever you communicate with your employer or your boss about your request for accommodation, it's usually best to put that in writing, ideally by email, in order to keep a record of what's been said and who said what and when. I know that's not always possible, but where it is possible, it's a good idea to keep a record or keep notes about what you said to your employer and what they said to you when you discussed accommodation. The employee, as it says here, does have to provide enough information about their individual circumstances to justify the accommodation they are seeking. And once again, it's important to emphasize and to repeat that alternative forms of accommodation suggested by the employer have to be given a chance. Even if the accommodation proposed by the employer is not the same thing as the worker requested, the worker usually has to give it a try. Once the legal requirement is for the legal requirement is for reasonable accommodation, not perfect accommodation. That can be frustrating for some employees, but it is supposed to be a process that involves compromise and some give and take between employees and their bosses or their employers. I'm moving into another slide about the employee's responsibilities. And this repeats something I've already said, which is that the employee must participate in the accommodation process by providing reasonable information that proves they have a disability and that explains how their disability affects their ability to do the job. The employer can ask, they are allowed to ask for medical information, like a note from a doctor or from another healthcare worker. And they can ask for information about how the employee's disability affects their ability to do the job. And also, the employer can ask for medical information about the employee's compliance with their treatment plan. This does not mean the employer can ask for details about the treatment plan itself. For example, let's say that the treatment plan that the doctor has provided for a worker involves taking medication that would help the worker to do their job. The employer is allowed to ask for confirmation that they are taking their medication. They are not allowed to ask what is the name of that medication or what does it do. They just need to know that the worker is doing what they can to get better or to get treatment or to participate in their treatment plan to make sure that they are ready to work or able to work if possible in light of their disability. So now I'm moving into my section about some examples of workplace accommodations. So I have just a few examples here, just to give you an idea of what I'm talking about. And in a moment, I'm going to open it up and ask if anyone else can suggest other examples. Because I want to emphasize that this is not by any means a list of all possible forms of accommodation. The possibilities for accommodation are almost endless. But some examples that I've listed here include modifying someone's duties. And this could mean, for example, that they have more frequent breaks throughout the day, or they have more frequent check-ins with a supervisor to monitor how they're doing. It could also mean changing how information is shared, for example, by sharing information in writing instead of giving it verbally. Other examples of workplace accommodation could include modifying the physical layout of the work area. For example, assessing the employee's work area for ergonomic barriers or challenges, and making sure that their work site or that their work area does not aggravate their disability, especially for people who have, for example, physical disabilities that mean that they can't sit in one place for a long time or stay in one position for a long time. In some cases, modifying the work area could mean changing the lighting in your workspace, or it could also mean moving a work area to be closer to required equipment. For example, there's a person in my office who needs to use the photocopier very often, but they have a disability that affects their ability to move around the workplace. And so it made sense to move that person's desk to nearer to the photocopier so that they don't have to move around so much in order to use that equipment. I have one more slide with some examples of workplace accommodations. As it says here, sometimes accommodations means providing special equipment. And this could include screen reader software for people whose disabilities affect their vision. It could include earphones or microphones for people with hearing loss, or hands-free telephones in some cases. And then one very common form of accommodation is to give people time off to access treatment. Sometimes this just means a few hours at a time to go to an appointment, or a few days here and there to travel to get treatment or an appointment in some city that maybe not the same city you live in. It could also mean allowing someone a longer leave of absence. For example, if it's going to take someone several months to recover from an injury or from very serious symptoms of a disability, the employer is usually required to give them time off. Most of the time, the employer is not required to pay them for that time off, but they are required usually to give the employee a leave of absence so that they can recover or so that they can get treatment for their disability. Now, at this point, I want to try to do something a little more interactive, because I realize I've just been lecturing at you so far. I want to ask if anyone can think of any other examples of things that an employer could do that might count as reasonable accommodations for a person with a disability in the workplace. So I will suggest that you could put that in the chat. If anybody wants to speak up, that would be fine too. And I will say I'm just now actually opening the chat for the first time, and I see that some people have put questions in there. And I have to say, unfortunately, I have not had a chance to look at the chat till now. I will do my best to answer those questions when I have a chance. But for now, I want to ask if anyone can suggest any other forms of accommodation that they have experienced or that they've seen in the workplace, or that they could think of that might be appropriate for a person with a disability. And I see a lot of people are suggesting remote work and working from home. And I think that's a really interesting example, because this is one of these things that, 5 years ago, employers would have said, no, you can't work from home. That just isn't going to work. We can't have that happening in our workplace. But then the pandemic happened, and many people were working at home for a long time. And so we've learned now that it is possible for many people to do their job effectively, even remotely. And so working from home or working remotely is a good example of a form of accommodation that might be available now that we didn't know was going to work quite as well just a few years ago. I'm seeing a lot of other great examples in the chat. For example, using a sit or stand desk, allowing flexible starts and stop times for the workday, making sure that communications are clear and less abstract, and using direct language. Allowing guide dogs in the workplace. I've definitely seen some examples of that in recent times, and I think that is a great idea. And I'm just I encourage everyone to look at the chat, because I'm not gonna have time to read out all of these examples, but I'm seeing some really interesting examples of possible forms of accommodation. And some of these I've seen before, and some of these I haven't actually seen before, and I think that they are really good suggestions. There's a question I see about whether providing transportation or supporting an employee's commute to work can be a form of accommodation. And that's a very good question. And I'm not sure that I know the answer to that. I think it is really going to depend on the particular circumstances. But it's another example of times where maybe working from home is might be an appropriate form of accommodation to ask for. I see a question in the chat about how do you handle rigidity towards work from home, and I'm not surprised by that question, because I've received questions from clients saying, well, I think I need to be able to work from home to accommodate my disability, but my employer says no, I need you in the office now that the pandemic's over. It's time to come back to work full time. And I know that a lot of employers are pretty insistent that it is important because of the type of work they do to actually be there in person. Every circumstance is a little different, but I think the best advice I could give about that situation would be to try to get a doctor's note or a note from, for example, a psychologist or some other professional healthcare provider that explains the connection between a person's disability and their need to work from home. I don't know if that's always going to be enough to convince an employer to allow a person to work from home. But in my experience, that is often a good way to start the conversation and make sure that the employer at least takes that request seriously. I'm just skimming through a few more things in the chat, some of the suggestions I've seen. As I said, I can't read out all of them, but there's a few that have just become very interesting for me. One person has suggested employees can create sort of a carved out position for an individual based on their ability to do tasks. And I think that's a really interesting example, because sometimes a person's disability means they can no longer do a job that they used to do. And in some cases, especially with big employers, like the government, for example, the employer might be required to not necessarily to create a whole new job for them, but to take pieces of other jobs and bundle them together to create a job that a person with a disability can do, even if they can't do their previous occupation. There's a question in the chat about whether if you're a caregiver for someone with a disability, does that qualify for accommodation? Excuse me, not in the chat, but in the Q&A. And that's a really good question. I'm not going to have a chance to answer that in detail, but what I will say is, one of the things I did not mention earlier, but one of the other protected grounds in human rights law is referred to as family status. In other words, if you have a family relationship to a person that affects your ability to do a job. And in some cases, family status discrimination can happen if you have caregiving requirements and your employer does not accommodate those requirements. But I will have to say that is a complex area of the law. And I would not want to, I don't want you to understand me to be saying, yes, you definitely have the right to accommodation because you have caregiving responsibilities. It's really dependent on the circumstances of the case. In a situation like that, if possible, I would urge someone to try to get legal advice about their particular situation and how the law applies and how the law of accommodation applies in that situation. So thank you for all those examples. I really appreciated all your contributions to that. And as I said, there's some examples here that I have not seen before that I think are great examples of things that employers could reasonably do to make sure that people with disabilities are able to thrive and to do their jobs in the workplace. I've got just a few more slides I'm going to go through before I open it up to any further questions. I want to talk about what happens when something goes wrong. So the next couple slides are about the fact that sometimes it is necessary to take legal action to enforce human rights laws. Taking legal action to enforce a person's human rights usually should be seen as a last resort. If you have already asked for accommodation and provided information to support your request, but the employer just isn't being reasonable. Unfortunately, taking legal action can be quite stressful and slow. It's not a fast process, but sometimes it is the only way to make sure that human rights laws are respected. This slide is called Submitting a Human Rights Complaint. As it says here, most employers are regulated by the provincial or territorial government. So human rights complaints would have to go to a provincial or territorial human rights tribunal or commission. For employers who are regulated by the federal government, complaints go to what we call the Canadian Human Rights Commission. And I've listed their website there. It's chrc-ccdp.gc.ca. I wish I could have also listed the websites for all the provincial and territorial human rights tribunals and commissions, but unfortunately, I just didn't have the space for that. There's at least one in every province or territory, and so it would not make sense to list them all here. But every province or territory has some version of a human rights tribunal or commission that a person can make complaints to when the employer is not being reasonable and not accommodating their requests for accommodation. I should also add, employees who are members of a union might be able to enforce human rights laws through the grievance arbitration process if their union supports them. I said before, but I want to repeat that unfortunately the human rights tribunal process is slow, and it can take many years from when a person starts the complaint process to when the tribunal makes a final decision about it. So it's not a process that you should start if the only thing you want is a short-term solution. But sometimes it is worth the wait, because in some cases, the tribunal, a human rights tribunal, can force businesses and governments to make major changes to how they operate and how they treat employees. I want to emphasize that's difficult to achieve, but it can be done. And so sometimes it's worth going through the long, stressful process of the Human Rights Tribunal or Commission to get that. I also talked about the grievance arbitration processes for unionized employees. And I should add that the time that takes may vary. It's hard to say exactly how long it's going to take, but in general, a grievance takes less time than a human rights tribunal case. So if the grievance process is available to you because you're in a union, that's something that you should seriously consider talking to your union about before you file a human rights complaint. In some provinces, you're not allowed to file a human rights complaint if you're a unionized employee. In other provinces, this is allowed, but even where it is allowed, sometimes the grievance arbitration process is the better option. This next slide is called Enforcing the Right to Accommodation and Seeking Legal Advice. And I can't emphasize enough how important it is to try to get legal advice if you're considering a human rights complaint. I know it may be difficult to talk to a lawyer because most people in this position, or many people in this position, don't have a lot of money, but it can make a very big difference to the outcome of a human rights complaint. I've included in this slide just a few examples of some of the tricky legal issues that make it important to seek legal advice. One of them is the deadline issue. Usually in most provinces, there's some exceptions, but mostly you have 1 year from the date of discrimination to take legal action. But determining that exact date of discrimination can be tricky. And so it's not always easy to figure out what is your deadline. Even if you meet your deadline, the process can be complex and cases can be dismissed for procedural reasons. You might say that as being dismissed based on a technicality. And that's something that if you get legal advice, you might be able to avoid. Moreover, in many cases, the employee may hire a lawyer to try to prove they did not discriminate. And if you're up against a lawyer, it is helpful if you have legal advice of your own to try to navigate that situation. With respect to a grievance in a unionized context, the unionized employee who believes they were discriminated against should talk to their union as soon as possible. The process and deadlines for that are usually set out in the collective agreement. But again, that only applies if you are in a unionized environment. It would not apply to employees who are not in a union. And just going back to getting legal advice, I know that in big cities, in the big provinces, like BC and Quebec and Alberta and Ontario, there might be legal aid clinics who can help with providing legal advice about human rights. For example, my office, the Disability Law Clinic here in BC. But I know smaller communities and many provinces don't have these resources, and that makes it more difficult to get legal advice. And in those cases, you might want to search for a lawyer referral service that is operated by a nonprofit organization in your province or territory, or it might be operated by the provincial or territorial law society. I'm almost at my conclusion now, but before I conclude, I want to talk briefly about accessibility laws, because I believe they might be sort of the future of accommodation. These are laws that have only started being created in Canada in the last few years, and they're supposed to prevent discrimination by removing barriers. The main difference between human rights laws and accessibility laws is that human rights laws require people to complain about discrimination before anything can be done to fix a situation. Accessibility laws, if they work right, are supposed to prevent discrimination from happening at all, to prevent it from happening in the first place by ensuring that people with disabilities do not face barriers at all. Some provinces don't have accessibility laws yet. Ontario has had one for a long time now, and also Manitoba and Nova Scotia have some version of this type of law. Quebec and BC also have sort of a weaker version of this type of law that has a more narrow focus on government services. And the federal government also has a version of it, has a law called the Accessible Canada Act in areas that applies to areas of life and areas of the law that are under the federal government's control. So these laws don't exist everywhere, but we're seeing them growing as a phenomenon in Canada, and I'm hoping that in the next few years, they will exist throughout the country. In terms of how they work, Canadian accessibility laws do not themselves contain specific rules about accessibility. Instead, they set out a process that governments must follow in order to make those rules, called accessibility standards. And accessibility standards are specific rules to ensure that people with disabilities do not face barriers. I'm going to give a few examples of those in a minute, but I'm just going to go through this last slide on accessibility standards. The goal of these standards is to make society more accessible for people with disabilities by removing barriers to accessibility proactively instead of waiting for people to complain about cases of discrimination. And these standards apply to employment, but they also apply in other areas of life, or they're supposed to apply, they hopefully will apply to other areas of life, including transportation, government services, and the built environment. In other words, everything that gets built around you, like roads and buildings and parks and anything else that, that is built by people. Unfortunately, compliance and enforcement of these laws is not consistent. I said before that Ontario has had an accessibility law for the longest time in Canada, or of any Canadian province. And I know that a lot of people in Ontario are concerned that the Accessibility for Ontarians with Disabilities Act is not being properly enforced. In other provinces, the laws are very new and we don't really know yet how well they're going to be enforced. But this is a concern, and it's something that we should be concerned about, is how well governments are protecting the rights of people with disabilities by making sure that governments, and in some cases private businesses, are complying with accessibility laws. I want to give some examples of what accessibility standards might include. One example that is already a requirement in some workplaces in Ontario is that employers might be required to create individualized accommodation plans for all employees with disabilities. This is similar to how you might be familiar with schools are required to create individual education plans, or IEPs, for students with disabilities. I think as Canadian society might be moving towards doing something similar for employees with disabilities, so that there is a formal place you can look and say, these are the accommodations that I'm entitled to. Here's what I need to do. Here's what the employer needs to do, instead of a more ad hoc, inconsistent process for designing and maintaining accommodations in the workplace. Another example outside of the employment context of accessibility standards could be specific requirements for the built environment, like, for example, ramp requirements on public transportation and indoor and outdoor spaces. or requirements for accessible parking or accessible trails and paths to services and amenities like playgrounds and beaches and other places that people want to get to. So those are just some examples of accessibility standards. The list of possible accessibility measures is almost endless, and we'll probably see over the next few years what different provinces in Canada want to do about accessibility laws and promoting accessibility and eliminating barriers for people with disabilities. I don't know much about Ontario's experience, but I think in the next few years, we're going to be learning a lot more about how accessibility laws and accessibility standards affect employees in the workplace and to what extent they prevent discrimination from happening in the first place, to what extent they make sure that employees who need accommodation are able to get it without going through the challenging process of making a human rights complaint, for example. So that is everything I wanted to say about accommodation of people with disabilities in the workplace. Thank you very much for the opportunity to speak to you today. I hope this presentation has been helpful. I hope there's some questions. I have some time. I can try to answer some questions. I see there's a few in the chat, and I will try to go through and answer some of those. If anyone wants to speak up and ask their question, I am open to that too, if that's possible. Thank you all very much, and I'll start going through those questions now, but I do appreciate everyone paying attention to me for this lecture. I hope it was sort of interesting for you. It's certainly interesting for me.
Thank you so much, Andrew. So we'll just open up for the questions. And meanwhile, we are going also to open up the polls for your feedback.
Sure, thank you. And so I see that Anne has the hand up. And yeah, I see you've unmuted yourself.
Yes, thank you. I can't start my video for some odd reasons. Thank you for your help. I had put a question in the chat, but my son is a 17-year-old who has a disability, physical disability. He uses a power chair for mobility. And I'm wondering, what is the best way? I mean, he's looking for a job, it's his first job, he doesn't know how to handle this. Should he divulge his disability firsthand? I mean, the nature of disability is that he's weak, so there would have to be certain accommodation, perhaps work share, as you mentioned, and so forth. And you know, compounded to that is 17, is shy, and so forth. So how do you have any suggestion how you should handle this?
Right, that's a tricky question, and I know it's different for every person. And I know a young person like your son is particularly vulnerable in a situation like that. I mean, different people use different strategies for that. I know some people who are very open about their disability and very upfront about it, but that does take some courage in a lot of cases, because we know that although there shouldn't be, there is often a stigma associated with disability, and sometimes employers are not allowed to say this, but sometimes behind closed doors, they might say, let's not hire this person. They're just going to be taking up too much time, causing too much trouble. I'm really not in a position that I could give specific advice about your situation. What I'm going to do instead, I'm putting in the chat, and I hope it won't get buried in the chat. I just put in a link to a publication that my organization, Disability Alliance BC, produced a few years ago called the Disclosure Guide. And it's specific to BC, but it's also, many of the principles there apply in other provinces, and it has a lot of information about things to consider when you are considering whether to disclose your disability either before or after you get a job. I should say a person is not required to disclose their disability before they get a job. Sometimes it will be obvious, right? Some disabilities are visible, and an employer is going to know about it when they interview a person or when they consider hiring them. Yeah, I know that's not very concrete, but I hope that you could find some suggestions in this disclosure guide. And I see that someone else has suggested in the chat doing role play around disclosure conversations, sort of practicing. I think that's sort of getting at practicing just like you would for a practice job interview. So I think that's an excellent suggestion as well.
Okay, I'm based out of BC, and I work with Mosaic and Disability Alliance. So thank you for putting the link. I'll access it. Thank you so much.
That's great. I saw a question in the chat a few minutes ago about, for an employee that with a disability that necessitates taking medication at certain times of day, would it be reasonable to ask the employer for a modified work schedule? And I think it's certainly, it could be a reasonable thing to ask for. Again, I can't say for sure that an employer is going to be able to accommodate that request in every situation. What I would suggest is, if possible, getting medical documentation, like a doctor's note, to explain why you're making that request. I think that would make the employer more likely to take it seriously. And I just see someone is saying that it might not be possible to access that disclosure guide link right now. And that might be because too many people are trying to access it at one time, and our website might not be prepared for that kind of traffic. I hope that you'll try it again. I suspect if it's not working now, it should be working in a short period of time. Esther has a hand up. Esther, are you able to unmute yourself?
Yeah, thank you very much. I was actually moving from filling out the poll, the webinar poll that was just sent out, but I also had a question relating to accessibility standards.
Right.
I think I would first of all want to say thank you very much for including that in your presentation today. I think I found that that and all other pieces really, but the accessibility role is very much close to my role where I work. I work at a school board in Southern Ontario, and one of the issues that I found relating to what you spoke about is the challenges with compliance and enforcement, and right now within the education sector or circles, we are also looking out to see whether the proposed education standards will fall through. So my question to you, Andrew, and I know this might be more specific to the Ontario environment, but for someone or for folks who are leading or who are supporting or coordinating accessibility within their organizations in one way or another, how would you advise, what strategies would you advise in in having more successful buy-in, whether it's from trustees or from managers or service departments within the school board environment? How would you, what would be your advice to have these conversations? Because if it's not on a checklist item that is currently relating to a compliance item, then that discussion is simply not happening. Or when it happens, the buy-in is not there.
Right. So I know that can be frustrating, and I know you mentioned you're from Ontario, and I know Ontario's got a lot more experience with accessibility laws than the rest of the country, because the law there was introduced much earlier than these laws were in the rest of the country. And so much of the country is sort of looking towards Ontario and seeing how compliance is happening there. And to be honest, it doesn't make me in particular feel very optimistic about it in other areas. To answer your question about how to, I think you're asking sort of how to get, in this case, your workplace is an educational institution, how to get them to take accessibility and accessibility standards more seriously.
Right.
I think, I mean, the best thing, I think the best thing I can think of is education. And I know that that's easier said than done, in the sense that it shouldn't be, but it might be up to the person who wants to promote accessibility to bring these issues to the attention of the trustee, of the school board, of the management there, and to make sure they know what their obligations are under the law. That might mean looking online for resources for institutions that have to comply with accessibility standards and pointing management towards those resources. In some cases, if management is not complying with the standards, it might mean making a complaint. I have to admit, I'm not familiar with the complaint process in Ontario. I know the complaint process varies a lot depending on which government we're talking about. So the Federal Accessible Canada Act has what appears to be a pretty robust complaint process where there's an independent decision maker who will assess your complaint. Whereas here in BC, the version of the law that we've seen here says, well, you can complain to the person who has violated the standard, but that's all you can do. And if they don't do anything about it, there's not much more that you can do. I think beyond that, the best advice I could give would be to seek further advice from a lawyer in Ontario who has expertise or experience with accessibility standards there. And in particular, you might already be familiar with this resource, but I would, in Ontario, I would refer people to the Arch Disability Law Centre, which is located in Toronto, but serves people throughout the province. To my knowledge, they are the people who really have the most expertise about accessibility standards and how to promote accessibility laws in Ontario. That's the Arch Disability Law Centre. I hope that's somewhat helpful, Esther. I know it doesn't exactly answer your question, but it's unfortunately not all within my area of expertise.
No, it's very, very helpful. Thank you very much.
Well, I think we've reached the end of our time. Thank you again for having me here, and thanks to Tekla and for helping to organize this presentation. And I once again, I hope it was helpful for everyone. I hope you get something from it that you're able to use in your work going forward.
Okay, thank you so much. And thank you everyone for participating. So I wish you a good afternoon or a good morning, wherever you are. And we hope to engage later. Thank you so much.
I know.